Thank you so much. Thank you for the introduction. Thank you for this really nice event. I've been learning a lot. I will just set my timer. I don't want you to
Thank you so much.
lose my
Thank you
time
for the
here.
introduction.
So,
Thank you for
the title of my presentation is Crimes Against Future Generations, which is a legal good theory problem. I split my presentation in 6 parts. I will start with a brief introduction of what is really the legal good theory, what is this, what is its objective, and what is a legal good at all. My main question here is, can we protect future generations through criminal law? And about that question, the legal goods doctrine gives us 3 different answers. I would like to dialogue with them, with each of the answers. And I think we have to ask, what are future generations? This is a concept we talked about in many of the panels. I think we have to take a deep look of what future generations mean, because I think there are 2 different concepts for it. And then we have to go in the to have to enter in the discussions of if future generations have rights, and if we as present generations have duties towards them, and how the answer should that affect my initial question. On the other topic, I would like to ask which crimes could be considered crimes against future generations, because in a cumulative way, every crime could be a crime against future generations. And I will finish arguing that only serious environmental crimes are crimes against future generations. So, for a brief introduction, it seems to me that we're tackling here 2 main problems, and I turn them into questions. The first question is it justifiable to criminalize conducts that are harmful to future generations? And this question is addressed to the state, to the legislature. And we are asking uh, about the limits of the power of the state to criminalize conducts. Can we criminalize conducts that are harmful to future generations? Is it legitimate? This is my first question. And the second question is addressed to the judge. So my colleague who is a judge could help me on that as well. The question would be, is it justifiable to increase or to aggravate criminal sanctions to harmful actions to present and future generations? So when a judge uh, has to decide on a case, in this case, uh, in this case, a conduct is so serious it will harm people from the future generations. Can he or she increase or aggravate the criminal sanctions on this basis? This is my second question. This is my second problem. And then our larger problem that get these 2 questions is, we are trying here to find substantive criteria to justify criminalization. We are not, this is not sufficient to give a democratic reason. Just because the legislator voted for that crime, for that bill, and enacted a law of a new crime, that is not sufficient in order to say that this criminal provision is legitimate. We have to find another substantive and not formal criteria to kind of challenge those criminal provisions. And then the legal goods theory gives us an answer. We can discuss if that answer is valid or not, but I'll try to bring the legal goods theory as a premise here. It is a criminalization theory, and it asks and answers the question of under which conditions can the state punish behaviors, and its answer is only when the conduct is violates legal goods of others. That would be the short answer. We will then discuss what are legal goods indeed. Our specific problem is, are future generations entitled to legal goods? This question I would like to answer in the end of my presentation. So, what are legal goods? Legal goods, or Rechtsgüter, according to Professor Klaus Oxin, that was born here in Hamburg, if I'm not wrong, and Professor Luis Greco as well, are those that are essential to the individual's free development, the exercise of one's fundamental rights, and the proper functioning of a constitutional state designed to uphold these objectives. This concept can be divided into individual and collective legal goods. There is a very personal idea here that the state has to protect humans, has to protect person. It cannot protect itself just by that basis. And the idea that criminal law is the most strong tool that the state has against the individual, and that's why you have to be careful with that. Then the legal good theory has a personal, therefore anthropocentric basis. The question of an ecocentric approach is not quite useful here because we're still talking about humans. But traditionally, the legal good theory is anthropocentric. And then to end this part, I would like to quote Professor Karl Friedrich Stuckenberg, who is an opponent of the legal good theory, but he summarizes it in a really, really interesting way. So what is the aim of the legal theory? It's that a criminal law provision is considered illegitimate if its aim is the protection of something that does not count as a personal legal good, such as public morality, religious commandments, abstract collective interests, or the paternalistic prevention of self-endangerment. In Brazil, for instance, we punish asking people for money, begging. So what is the legal good on that? Not no legal good at all. Within the theory, and to face the question of if we can justifiably protect future generations in criminal law, there are three different answers: a negative answer, a positive answer, and what I would call an out of the theory answer. The first answer is negative. So Professor Plitvitz states that the legal good theory only refers to interests of living and real people. This is very traditional, right? Criminal law wasn't developed thinking of other things that are not a relationship between an author and a victim in the present. So the theory wouldn't, the idea of protecting future generations wouldn't fit. Professor Hirsch states that he goes the same way. He states that the idea of unfairness requires coexistence and reciprocity. We can't have a reciprocal relationship with future generations. We affect them, but they can't talk to us back. We can't do anything because they don't exist yet. Then we couldn't, by this negative answer, protect them by through criminal law. We have a positive answer. Professor Bernard Schumann, Professor Luis Gracia Martins from Spain, they state that in a social contract approach, we are obliged to protect future generations. This is a fundamental norm of the social contract. If we can't protect future generations, so what is the need of a social contract? It's very egoistical to have a social contract just for the present generations. Then we would take international equity as a principle here within the legal goods theory framework. On the other hand, Professor Wilfried Neumann and Professor Helena Regina Lobo da Costa, who was my supervisor in Brazil, they say that future generations are humans who have personal interests. So there is not a problem here. The legal good theory doesn't care if the person is alive today or tomorrow. The idea is that we have a restrictive approach to criminal law, and we have a criteria of a personal interest that fits for as they answer this question. And lastly, Professor Klaus Oxin and Professor Luis Greco, they state that no, we cannot protect future generations through a legal goods theory framework, because one of the requirements would be that the harmful conduct affects negatively the coexistence of people, and future generations are not coexistent. But they state we still have to protect future generations under the solidarity principle and on the basis of the duties that we have to protect the environment for future generations. I call that an out of the theory answer because they say, okay, we could not justify this kind of criminalization through the theory, but it is justifiable by another principles. So I'd like to ask, what are then future generations? It seems that we must clarify that. It seems to me that we have two possible concepts. We have a broad concept and we have a strict concept. For me, the idea of future generation is not taking a picture and say, okay, we are the present generation, and what comes next, like the baby that is going to be born in 10 minutes, he is the future generation. I think that's kind of forced. I think we have to take a realistic approach. So, my grandmother is 83, I am 25, and I have a cousin who is 3 years old. My cousin and my grandmother are healthier and fitter than I am, and we coexist in some way. My grandmother was part of the past. My cousin will be alive in the future for the next 80 years. I hope so. Then we are in some way coexisting in the time. We are overlapping generations. So a realistic approach for me would take into considerations that generations don't live apart from each other. They're always succeeding each other and they coexist in some way. So there are uh, present interests and present legal goods now of concrete persons that will continue to exist in the future. But we can take a strict concept as well. We can talk about a non-overlapping generation. And then we will take the picture and say, this is the present generation. Or we can say, I only consider future generations as people who are not still into existence. That would be okay. I think that there is only a group of crime that would refer to these kinds of generations that would be crimes related to human genetic engineering. The embryo is not a human. It doesn't have interest. I think this is not. This is very. There's no consensus over that, but you got the idea. If we kind of edit the DNA of the embryo and the future generations related to this embryo have diseases related to the conduct of editing, then that would be the only group of crimes that affects strict non-overlapping generations. But I wouldn't like to go there. It's another discussion. I'm just we focus on environmental crimes. And then we have to ask if future generations have rights and if we have duties. Most scholars tend to answer the first question with a resounding no, and I would like to uh, to agree with them because uh, someone that doesn't exist cannot exercise a right. Someone that does not exist can't have rights to something that we don't know if it will exist in the future as well. See, the dodo, that bird that has gone extinct, uh, imagine it and imagine the generations that coexisted with the dodo. They had a right to have that biodiversity and the dodo in that biodiversity. But the dodo is extinct. It doesn't exist anymore. I, as a future generation related to Dan, don't have a right to a ecosystem with dodos anymore because the object does not exist. We don't know what kind of object will exist in the future. We have also identity problems, so this is kind of tricky. And for me, it seems unnecessary to go this way because we, as present generations, have duties towards future generations. That is the legal basis of my answer in the end for two reasons. First, we have uh, a domain over future generations. How we act, how we behave, will shape the world for them, will shape their identities. So we can have some kind of control over their lives. That's why you have duties, obligations towards them. That's one reason. The second reason is that they are vulnerable and they can't do anything about that. We have the power on our hands, just as the past generations did with us before we ever existed. And we have duties towards future generations, and that's why I take a present rights of future persons approach. We will always have present interests and present legal goods that will be harmed in the future by present conducts. We will not have to enter in the discussions of rights and legal goods of people that don't exist because that is enough. We already have concrete persons existing that will exist in the future. So then we have to ask, how do we harm future generations? Because in a way, every crime affects future generations. If I kill someone, I will make it impossible for future generations to exist from that person. In this kind of logic, it's a crime against future generations. Tax crimes and corruption crimes. Uh, those crimes will give less resources to future generations to invest in education, in culture, in transportation, right? So in some sense, we are harming as well future generations and their ability to have enough resources for services, etc. Crimes against democracy. If we overrule the state, which almost happened in Brazil, we are harming future generations because they will not have the protection of a democratic state in some way. But then uh, that would lead to a exponential expansion of criminal law. We would have to turn it like with higher sanctions to every crime. That wouldn't be prudent. Then we have to take a restrictive approach. And also, I would argue that we have to take a constitutional approach and check what our constitutions say or state about future generations. They mainly say that the duty to protect future generations is regarded to internal and external conditions for the continuity of human life. Then here is the Article 225 of the Brazilian Constitution. It states the right to an ecologically balanced environment. And here it states that government and community have the duty to defend and preserve it for present and future generations. And then Article 20A of the German Basic Law states also the responsibility towards future generations, and then that the state shall protect the natural foundations of life and animals by legislations and so on. So our constitutions, they state duties towards future generations in regards to the environment. But then we have another problem. Does that mean that every crime, every environmental crime is a crime against future generations, and we have to punish hardly every environmental crime? I think that answer is also no. If, for instance, which is very common in Brazil, if I have illegal fishing, but low is illegal fishing, or if I cut 3 or 4 trees in a protected area, this concrete conduct won't harm future generations. Yes, in a cumulative sense, yes. If we all do it for a week, that will harm future generations, but only that concrete behavior, no. Then I think we have to match 2 conditions to state that a conduct violates legal goods of future generations. We have to have present people with correspondent interests that will exist in the future. It's the case of my cousin will exist in the future. And we have to take a look on the seriousness of the harm, that harm will continue to produce, that harmful conduct will continue to produce negative effects in the future. The seriousness of the harm for me is the key concept here, the key condition. Then to finish my presentation, I still have 1 minute and 30, but to finish my presentation, only serious environmental crimes for me are crimes against future generations, and that would allow the legislator and the judge to take actions on this basis. For example, we had the Mariana Dam disaster and the Brumadinho Dam disasters. They were man-made natural disasters. Those are related to 2 mining companies that produced a toxic material leak that killed many hundreds of people in Brazil, and that destroyed the ecosystem of the area. The liquid material that is toxic, it went until the ocean. It was very, very serious. That would be an example of a crime against future generation. I think ecocide is a crime against future generation, but I will leave that to my colleague who will talk about ecocide. We have in Brazil 2 bills about ecocide, trying to criminalize ecocide in Brazil because of those 2 situations. And then we are having a discussion, particularly in German, about climate crimes. that are related mainly with illegal emission of greenhouse gases. The legal good here would be the atmosphere, and I'm not quite sure if that's enough to say that those crimes are legitimate, because it's difficult to think of a single action that could harm the entire atmosphere. I think that would be only a kind of criminal administrative law in some way. I don't know, but that's up to discussion. Thank you very much. Uh, that was 30 seconds more than I thought. Thank you.
Thank you so much. Our next panelist is Jamal Hajiyev, master's student in international European law at Vilnius University with a specialization in human rights and environmental law. He holds a bachelor's degree in law from Baku State University and has gained practical and academic experience across multiple jurisdictions, including Azerbaijan and the European Union, and has contributed to legal research on environmental law as a young scholar. He is currently serving as a legal officer at an international company where he works on cross-border legal matters spanning all continents. And he will talk to us about Ecocide, as promised by Mr. Ishikawa. Thank you very much.
I have to put a timer, not exceeding the time. Yeah, like that. First of all, thank you for the great presentation to Vitor, and it's also related with my topic is ecocide, and it's related with the future generations. And thank you for Felix for a brief introduction. But as you see, it's not a long biography because I'm only 21 years old now, and I'm pursuing my master. And I hope one day I will add my PhD journey to my biography. We'll see. And firstly, we have to talk about my topic is ecocide, not as a theoretical issue, not as a political slogan, but it's a real, it's happening, enforceable, preventable crime. And we are currently, if we are searching our legal system and observing some gaps, and we can say that we have some void with some legal vacuums about the ecocide and the other environmental crimes. And after that, we should see the climate crisis is a legal crisis. So because we have a irreversible damage, rising global temperature or biodiversity loss threaten people, our whole planet. Also, we have inadequate legal response. Most legal systems fail to recognize environmental crimes, environmental damage as a crime, and also global responsibility. And what is ecocide and why we are talking about this, why it's important? Actually, the first term ecocide introduced in 1970s and by biologist Arthur Galston in Washington. Actually, it's a conference, and as you know, during that period in 70s, it was a Vietnamian War, and the exact wording that Arthur Galston said, the defoliation of Vietnam is ecocide, the destruction of ecosystems by humans. And we are living through an unprecedented environmental collapse, climate change, mass deforestation, and ocean acidification and other things. It's not related with the one country because it's related with other countries across the jurisdiction, across the borders and generations. But while our science evolved, but our legal response, to be honest, has not in the current world. And ecocide is the deliberate, large-scale actions to the environment and the destruction of our ecosystem is not recognized as an international crime internationally. And in fact, the most jurisdiction, it's not even a crime. It's not exist. And but the harm is everywhere. And let's see some cases about the ecocide, and it happened in Ecuador. Actually, it's a Yasuni Park, one of the most biodiverse ecosystems in the earth. In 2023, actually, despite global outcry and also indigenous resistance, we saw that Ecuadorian government just opened the park. I don't know, 4 to 3% of the park for the oil drilling. And as the result, what happened? It's a mass destruction of the environment, species extinction, and also it's related with the destruction of agriculture and whole flora and fauna. But even this kind of acts happened, but we didn't see any conviction or not any person just made held accountable for their actions. And we see the gap in here because we have actions, we have environmental damage, but no legal response these acts. And about the legal gaps, legal vacuum surrounding ecocide. At the international level, we have to see firstly, there's no recognition, as I said, of ecocide under the Roma Statute of International Criminal Court. A working definition actually was introduced in 2021 by the expert panel. Actually, I can say that it was a great milestone in the ecocide history in the field of law. And the definition was exactly unlawful or wanton acts committed with knowledge that there's a substantial likelihood of severe and either widespread or long-term damage to the environment. And even where national efforts we saw in the history in the previous times, but we can say that they are mostly symbolic and inconsistent. Like I can give you an example about France, and France adopted a law criminalizing ecocide, and they adopted it in the criminal code in 2021, but it's narrow in scope and primarily administrative in manner. And also in some Latin American countries that Vitor also mentioned about that. For example, Bolivia have taken steps to include environmental harm to criminal code, but often without enforcement or clarity. It's the problem. Worse, I will also talk about later the corporate actors. And we have to check the national frameworks first and the international level. In the national frameworks, yes, in theory, they are the closest ones to the criminal scene, and they're faster. They are connected with the victims, local people that affected by the damage. But the most cases we can see, the government always uninterested, unwilling to act. But what's the reason about that? I can give you example like the state is often part of the problem. Corporations always part of the problem, and they are subject in environmental harm. And judges, they should be independent. They are, but the main thing is that they are not trained in environmental science, and they are not totally capable to made accountable or just observing cases in the environment. And we should also consider international law and ICC. The International Criminal Court cannot currently prosecute ecocide, and even if it could, its you can say jurisdiction only limited with the states corporation, and after that, like states ending the corporation, it will fail. It relies on national system to prosecute suspects and deliver evidence and support this. It cannot act unilaterally. And the ICC only prosecute, as said, individuals. For example, if the CEO of the company signs either mining project or some area of poisoning a watershed, the court cannot indict the company. Like the structure that companies taking advantage and they are speaking from accountability, just hiding behind some gaps in the legal systems. And so if the existing legal frameworks cannot just meet the requirements, both fall short, but what should we do? Like from the previous times, we can see some hybrid legal models in the past times. We see that some tribunals, for example, the extraordinary chambers for Cambodia, also tribunal for Sierra Leone, also Bosnian war chambers. It's not just theory; it's a practice proven in the practice in the past. And why did they work? Why these tribunals? Why this hybrid model works? Because they created a legitimacy where purely international, of course, national legal systems cannot work efficiently. And they balance legal power with cultural proximity. And we are not talking about just replacing something. We should make a bridge between international law and national proximity, as I said. So if the ICC cannot just work efficiently, and they have jurisdictional and structural gaps, and they cannot prosecute, as I said, in corporations, only they can prosecute individuals. If it struggles with environmental evidence and if powerful countries are not parties, then what's the solution? The answer lies in existing and creating a new legal instrument, I can say, a new regulation, a treaty about the International Ecocide Treaty. And also, I'm proposing a model. I call it three-tiered model, enforcement model, or multi-tiered enforcement model, we can say. And it's not rely only the one failing system. It's make a bridge between elements of the national, regional, and also international level. And let's dive into about the first layer, national enforcement. And despite their limitations, as I said, national courts must remain in the primary position to the crime scene because they are close to the crime scene and they are close to the victim communities that are affected. They know the terrain, both legal and ecological. But if we want to proceed further efficiently and if we, in order to work efficiently, we need more than some symbolic legislation. We need domestic legal system that recognize ecocide as a standalone criminal act, as a crime. And I think in my proposal, I'm suggesting a new instrument like Ecocide Treaty. And with Ecocide Treaty, in practice, we saw it as a Rome Statute actually in the previous times for genocide, for example, and other international crimes. We already did that, and we have an obligation that which states ratify when they are ratifying the Roma Statute. They have to include these crimes. They are criminal codes. They are national legislations, and it means when we are criminalizing ecocide, we need a legal definition, clear legal definition to ecocide, thresholds for what's widespread and long-term damage to people and to environment, and procedural rights for NGOs and communities, and especially access to environmental information expertise in the courts. And even where national laws already exist, but we are not sure about, we must ask, are they enforceable? Are they can proceed without fear or favor? And let's be clear, national enforcement often fails not because the law doesn't exist, actually, because power dynamics prevent enforcement being used. And that's why we need external support mechanisms. And the second layer, I can say, regional environmental tribunals. The idea here is not new because, as we know, there have some regional human rights institutions that are operating in the regional level, like European Court of Human Rights or Inter-American Court. What I propose is nothing new. It's a similar system, but it should be specialized only in environmental cases, especially ecocide. And there's some question like, why do we need this actually? And because so many environmental harm related borders, cross borders, and transboundary characteristic. Because rivers don't stop in borders. Air pollution always shifts across the jurisdictions, across the borders. And if we saw some massive destruction, environmental harm, it is not really related only one state. It's related with all states. For example, especially neighbor states and especially fragile ones. And actually, regional environmental tribunals should deal some tasks like prosecuting cross-border ecocide cases, also offering legal recourse when national systems are unwilling or corrupted, and also harmonizing regional jurisprudence on environmental harm. They could also serve as a preventive measure, preventive function. Imagine let's say for example, Central Asia or Central Africa, we have a regional environmental tribunal that's dealing with overshared water resources. Meanwhile, in Asia, we have regional environmental tribunals that dealing with deforestation, massive deforestation, and which means this would ease the burden on global courts while dealing efficiently in the same time with the another issues. And next layer should be the important one, the International Tribunal for Ecocide. And I know that it can be seen ambitious or utopic idea, like creating and building structure from zero, from beginning. But and the top layer, I can say we should establish international tribunal, and this would be a global backstop. The tribunal would function similarly to existing international criminal bodies, but with critical differences. We know the ICC has limitations, as I said, no corporate liability, difficult amendment rules, and also political gridlock. But so instead of forcing ecocide to the system not designed for it, we should build a new purpose-driven treaty with a specialized tribunal, scientific panels, and regional coordination, I can say. Just like the Roma Statute established the ICC, this treaty, Ecocide Treaty, established an international tribunal dealing with ecocide cases. We call it the international. Actually, in the first glance, it should be International Tribunal for Ecocide, because naming the crime is the first thing we have to do. But its jurisdiction may extend with the progress in the future treaty development to other large-scale environmental crimes that require international prosecution. First, we should know that it would be specialized in the environmental cases, and it will be include interdisciplinary experts in some fields, ecologists, forensic scientists, geographers, and also it would be have a mandate to prosecute corporations, not only individuals. And also, like, the creation of such a tribunal would require political will, and actually, in practice, from the first glance, it can be challenging. But we did it for genocide. We did it for crimes against humanity, as we have 4 international crimes currently. But I believe that, and I hope that we can build this system for our planet also. And I actually, to be honest, the International Tribunal cannot solve everything properly, but it should be some starting point, and actually it should be the message for future generations that we are living this planet and we cannot destroy it if we are doing something wrong. The perpetrator, should be accountable. And also, let's see some interdisciplinary approaches, and we should also include the role of science and forensic in ecocide prosecution, because it's so essential. This emerging field combines toxicology, forensic scientists, climate modeling, biodiversity monitoring, and satellite imagery also. And think of the case involving illegal dumping into a river, mercury into a river. To prove it as an ecocide, we should check with water sampling data, satellite imagery, also some medical reports. We have some tools to make it prove as an ecocide, and actually it is the process of translation, I can say, because we are translating some evidence to legal field, to the legal language. And for me, it should be essential in the prosecution. Also, as I recall, scholars like Ahmed, as I remember, 2017, he also mentioned, and he proposed a new model like environmental forensic divisions in the international courts we can establish, and they are trained in environmental cases and also present such data in a legally pursued way. And I can say I fully support this idea also. And next, political science and legal harmonization. Let's say international relations should be important, because science alone is not enough. We need the politics of cooperation. There's where political science and international relations come in. Why do states cooperate with international tribunals? Why do some just accept it, but some of them just make obstacles, and even they are proponents of creating something like we saw it in Roma Statute, and we saw the establishment of International Criminal Court before. And according to Jering's dynamic regimes theory, and cooperation increases when states see legal regimes not as a threat, as a shared solution to the shared problems. And this matters for ecocide too. Because climate change, water scarcity, biodiversity collapse, they are not only my problem or your problem, it's all problem for our states, especially, as I said, fragile ones. And let's talk about comparative legal research, because we already mentioned interdisciplinary principle, but we should make a comparative legal research about and solve the problem, because we need to look across jurisdictions, compare legal cultures, and examine how different legal systems treat ecocide and treat environmental harm. For instance, as I said, France ecocide law may be narrow, but it offers a precedent for criminalizing ecocide, environmental destruction, at domestic level. Some Latin American countries, especially Ecuador and Bolivia, also in their system, they introduce rights of nature, as a concept, as a framework, a powerful legal philosophy that really centers nature, not a property, also a legal person. And also, as I mentioned before in my presentation, I'm from Azerbaijan, and actually I surprised the one news about Azerbaijan because in the end of 2024, the new law to amendment criminal code just introduced, and in the parliament, in the we call it Milli Majlis, and they also approved from the first reading the new law about ecocide and adapting it to the criminal code. And as I recall, they established up to 15 years imprisonment for ecocide crime. But there should be second and third readings. Of course, it's a pending situation. But at least it's a milestone for Azerbaijan, for our territory, just trying to provide it. But generally, I am not sure clearly if we are proceeding to adapt ecocide to our criminal code, it will totally work or not, because also in Azerbaijan we have some enforcement issues, of course, as like other countries. And implementing the model in practice, it should require, we should be realistic, like we should first proceed with a new framework, like a new treaty, and establish a new trend, like criminalizing ecocide in the domestic level, and amending penal codes, ratifying model treaties. Also, second, we should proceed with institution building, because it's really essential, and we are talking about three large model, and we should establish regional environmental courts. And also the last and the top, it should be international tribunal for ecocide. And also we need NGOs engagement, civil mobilization, and so on. And we have criminalized genocide, we have prosecuted crimes against humanity, and now it's time to declare with law, not just words, and that the destruction of the earth is no less serious. It's for me, it's more serious, more important than other things, because we are living in Earth, our planet. I can say, for example, forests are lungs of our planet, and if we are just massively destroying this nature, these sources, which means the existence of human beings at stake, and especially for the future generations, I agree with Vitor. Ecocide should be a crime, as also international crime, because it directly affects present times and also future generations because of the large scale and long-term impact to environment. And to be honest, the world doesn't need another weak declaration or something just in the paper. It needs a legally binding, enforceable, coordinated treaty, and like genocide or crime against humanity. If we fail to act, it means ecocide or environmental harm will be legalized, normalized, and forgotten. But if we have a courage, and if we are bold to take actions from the first point, I know it should take us some time, so some long period, but we should start from somewhere, and it means we can give to our planet and our future generations a deliberate need, not just accountability, but we can give also hope. Thank you for attention. It's the end of the presentation.
Thank you so much. For our last panelist, this is Rafael Elmer Cancho Alarcón. And he studied law at the National University of San Cristobal de Huamanga and holds a master's degree in criminal sciences from the National University of San Marcos. Additionally, he holds a master's degree in criminal law and constitutional guarantees and contemporary magistracy, justice in the 21st century from the University of Jaén in Spain, as well as a master's degree in cybercrime from the International University of La Rioja. He currently serves as a titular judge of the Superprovincial Criminal Collegiate Court of Ayacucho in Peru, and is also a professor at the Peruvian Judiciary School, AMAG, and an instructor at the American Bar Association School of Law Initiative. And today he will be speaking to us about the illegal online trafficking of felines. Thank you very much.
Thank you, Felix, for your introduction. Thank you, everyone who come here, and obviously the organizers for the event, and obviously to be here. Um, I am really a judge, and I'm free times I am researchers. A few moments, only a little. I think so. The conference from my partners is thinking to the future, and maybe mine is to think in the present. So we can speak, or we can begin with thinking in future, but working in present. I think so. Now I will talk about illegal trafficking online offline. It could have 3 months. The first time I will describe the phenomenon. The second moment will introduce the frameworks and the problems that exist in that thematic. And al final, I will try to make some ideas to continue working in the present. The illegal trafficking of lifelines is a problem that exists more years ago, maybe in different intensified, but after the pandemic of COVID-19, it increased in many places, especially in Latin America, Latam, how you say. I will expect to explain some of this that occur in Brazil, in Colombia, little of Mexico, and obviously in Peru. The perspective that I will try to give to the expositions, it could be that to insert the green criminology and the thinking of the future, but I'd say again, working in the present. I want to show that Latin American, like Peru, like Brazil, we have a biodiversity of felines. In fact, we are a country with megadiversity, not only biodiversity. We have a lot of fauna. Also, we have a lot of plants that we have to protect. 40% of the resource around the world of the biodiversity is in Latin America. Obviously, but like is the biodiversity, the principal research, we have problems. We have problems that we are extinguishing many of research in this ambit. Almost in this topic, the specific topic, the majestic predators like jaguar, or like we know in our country called otorongo, then puma, ocelot, and others felines are objects of attachment of attack from poachers that with the technology find with the consumers or with the global consumers, first in the United States, then Europe, and now I think more in Asia, the connections to increase the illegal trafficking of lines. So we are working how to confront the trafficking of lines online. The phenomenon of line trafficking online, it's complex. It's a complex problem. In fact, we have three fields, I think, that we find this problem. The first field is to use the traffic to buy exotic pets. Um, Basically, it means that the persons want to show their powers, having felines, maybe see in the films and the documentals, lions, tigers, but also from Latin American go everywhere. The jaguar, puma, and other species. The another field is the traditional medicine, especially in Asia. I'm sorry. There, the people use fangs, bones, and skin to try to. I don't know it's real cure, but like a healing or aphrodisiac properties. I don't know if real possessing that perpetrates, but they usually use these parts of the felines. The third field is the luxury goods and decorations. Obviously, like a carpet, like a luxury market. Maybe someone here have any part of the animals. I hope no, but we don't know. And three fields that are identified, especially by study by the International Fund of Animal Welfare, IFAO, that found that 888 jaguars that impacted by poaching or trafficking across Hispanic American between 2017 and 2022. But we know that isn't a real fact. Probably there are data and no data that show the real problem. So we can find for example, the jaguar, especially could be in extinction soon. It's a big problem like this. That problem, obviously, with digital platforms will increasing for many ways. For example, we can find here the use of the social media and e-commerce. In social media, we can find in Facebook and Instagram also many shows or many offering for this this product for the parts of the lines, but also the caps of the felines. No, with the names of felines, not with the jaguar, puma. You can find like this. You find with another names like mascots everywhere, exotic mascot, and there is the field, the first and the mainly chart when you found this. The second is the e-commerce sites like Mercado Libre that have the central place in Argentina, but all Latin American is using that, and everyone is every people that act like poachers. How they are using the social media and e-commerce, like the democratization of access to the internet, they use for the illegal, like in this case, like instrument illegal to commit that crimes. The second form, the second way that the digital platforms can use to the illegal trafficking of lines is the use of the dark web. And also here, not only the offering mainly to the transactions. Like people have to make the transactions, no, obviously, to see by authorities, obviously, no by regular law. They are using the dark web, especially the in this case the um, uh, that sites to make the illicit trade with no control, with nobody who can report these crimes. See, finally, we have the instant messages like encrypted messenger, WhatsApp, and another telegrams, maybe to have a contact, conversations to agreements to make the illicit trade. Obviously, it's not only the ways that we use or that we found in this illicit trade, they can change and are improving always. In relation to the second topic is to the frameworks, we have in nationals like Peru, Brazil, Colombia, Mexico, the following laws. First, we have acts that against that illicit, but the punishment is not equal in all the countries, and that represents a problem because in the assistant judicial international judicial assistant, we have to make the same or similar punishment to have, for example, the extraditions. And if we don't have, it can function like this. Second, always we found the conceptions that the constitutions, not all, because Ecuador, Brazil, eventually Bolivia, have a ecocentric protections from this way. But Peru, Colombia, and other countries have a perspective, anthropocentric perspective to protect that problem. And this is a big problem because the authorities or the officers here doesn't give importance to this problem, and they give more importance to drug traffics, for example, and human trafficking is a big problem, but they don't give the same importance. But we are working, but we are talking ecocide, we are talking about the gender, the future of the generations. Let's see. Then in the international frameworks, we have the Convention on International Trade and in endangered species of wild fauna and flora, called CITES. Here we have found jaguar, for example, in the Appendix 1. We found a margay also in Appendix 1, and another species of felines in Appendix 2 and one in Appendix 3. So this represents that identify that we have the problem, the threat exists in this field, but isn't that no that isn't sufficient to combat the traffic of feline in this field. Then that frameworks show some problems. We have legislative gaps. Many legal frameworks no design the digital, don't contemplate the digital way
¿Cómo está, doctor Pavel? Mucho gusto.
platforms or the use of
Mire,
platforms.
yo he salido de
to
una
permit
diligencia, pero estoy volviendo a mi estudio. Estaré ahí en unos 20 minutos. Ahí
punish
desde
more
ahí coordinamos.
serious this
Ya, pero sí, o sea, no hay problema. De mi
crimes.
parte,
The second, we
estoy
don't
está a su
have
disposición.
digital forensics personnel in digital forensics. That is a challenge that we have in front. Third, we have a big problem with corruption. The corruptions in our country is a big problem. I know that somebody talks about this topic, but we must note that in my country, especially in Peru, we have presidents that are convicted, are declared convicted, and others with prosecutors right now. Fourth is the law prioritizations because the conceptions that we have about the wildlife prosecution in this field, about the trade wildlife. Maybe yes, walking to the solutions or giving to the solutions, we can move into ways, or maybe we can embrace the two ways. First, embrace the green criminology, understanding that we don't have, or we don't need only the anthropocentric perspectives. No, we need the ecocentric perspective to protect the trade of illegal felines in this child. If we don't understand like this, we don't have, we don't keep the importance in this ambit to analyzing wildlife, trafficking of land, and no only this field with the another animals who are in risk to be in extinction soon. Then this perspective will change our form to see the problem, to think in the problem. Then we have to embrace also the multi-level governance, also with the relation with the national governments, international organizations, private sector, and non-governmental organizations, and local and indigenous communities. We have examples in Cusco that we are protecting the pumas with the indigenous people there. And we have to embrace that form to protect the felines, but not only one. This way, we have to, we need to specialize the forensic people to make a good investigation and sanction that or punish who commit these crimes. Then we need to make the similar laws in our countries to have a good relations to, for example, in restorations and assistant judicial also here. Well, this this topic is a big problem, and I know that we have many ways to confront this problem. Modernizing legal frameworks is the first way. Second, invest in specialized capacity. Second, with the forensic. Third, the forging and public-private partnerships. to arrive the cyber conservations states. No, how do you say? We have experience in Google, Facebook, and two institutions or three institutions that are working to contrast the offering in social media, the trafficking flying. But we have risk also here because the proof can lose, raising the offering, and we can sanctions or we can punish the responsible from these crimes. Another way, empowering indigenous people and local communities, and also the last, elevating international cooperations. I will apologize with my no fluency English, but I hope that when I give the article, you will read more completely. Also, I will try to respond our questions. Thanks.
Okay, thank you very much. We would now take, yeah, we have 15 minutes left before we need to change the venue. So, yeah, if you have questions.
Yeah, I have a question for Victor. Thanks for the talks. I'm looking from a public law perspective, but I think I find it really interesting your theory on the public, the legal good. And the harder I look at the future generation, the harder it gets to understand why you would have criminal prosecution for it. I try to coin a question that I think is challenging, but like good for you. I question what is the role of the temporal dimension of law in that case. Because if you look at the crimes that could be like the environmental crimes that you look at, which crimes are possible from one natural person, not a combination of several incidents, that is not imminent. So if it's the question then is this future generation a concept, a legal concept, to look at how destructive, how punishable an already existing crime is? And it's just a question how hard the punishment should be, because the implications of their harmful act is so severe, it still lingers on in 100 years' time. Or is it something that entirely different, that is just takes place within 15 years or 100 years, so a future generation is affected? And if you look at this second one, there are two questions. One is, what kind of earth do we promise to our children and grandchildren? And if the forest is gone, well, it's a forest that's gone, but it's still a livable place. And the other question is there actually any crimes left if we take away that's only one natural person that can commit the crime, and it's only those crimes that are not imminent, seeable, and felt, like the examples that you put forth with the mining incidents and similar cases that already take place at the same time. Thank you.
Thank you very much. Just to check it out, what would you call immediate? Like, what would that be? In which sense? Okay. I could think of two examples in two different directions. In the legal doctrine, they would give an example of a man putting a bomb in a place, and this bomb will only explode in like 100 years. Would that already be a crime or not? I think that answers one of the questions, like what about a situation in that which we have a conduct, and this conduct will only be harmful in the future? Is that the question? That would be one of the questions, right? Mhm. Yeah. Yeah, that would be really low, and then I don't think it's relevant to the discussion. Yes, the discussion is relevant when we're talking about crimes that are harmful to present generations and will be harmful to future generations, not within a year, but in 20, 40, 100 years. I would say that crimes related to nuclear problems are relevant in this sense. For instance, not only Hiroshima and Nagasaki, but also the Chernobyl incident. And also,
We
this,
should build
I'm
a
going
new
out of the nuclear example,
driven treaty.
only the Hiroshima and Nagasaki, but also Vietnam would also be an example of serious crimes. I don't know if I can state them as a crime in the legal sense, but they are crimes. There are crimes. And that would matter for the sanction, I think. I don't know. I don't think that we have some space to create new crimes in this moment. I think the discussion here is more of in the environmental part. I think the discussion here is more to how to aggravate the sanctions with the crimes that we already have. Although, as I said, we are discussing ecocide crimes. And the ecocide crimes are only relevant to future people, although they are already existing, because climate emergency is already a problem and the tomorrow is already today. We are late on this discussion. But in some way, illegal emission of greenhouse gases, the concrete illegal emission of greenhouse gases will only affect future generations in the future, right? I think the discussion on climate crimes are on this around this question. I think that's it. Hope I answered your question.
Well, thank you very much. My question is kind of similar, which has been asked, but I will try to go a little further. First, as you mentioned, the hypothetical, the future generations and the crime which can be created for if that's being affected. So, and you have given, and Jamal has also suggested that the what we call the ecocide specifically. So do you think that these crime, first of all, how you are going to establish these ecocide as a international crime? When we say international crime, it's usually based on either customary international law or based on a treaty. So, and the parties are becoming members to that particular treaty if the international communities agree to that. So, in this case, how do you proceed? For example, in the ecocide that has already been considered and specifically related to the future generations, right? In this case, as my friend has already mentioned, that how it's going to take place, like in few years or 100 years back, and you have given example of a nuclear disaster which could happen. So do you considering a person as a human being, like for example me as a responsible, or like I'm representing the institutions, or how you perceive and what kind of punishment can be provided hypothetically for that crime? Thank you.
Thank you for the great question and really complicated question, I can say. And first, I will start with about the criminalization ecocide. And as I mentioned in my proposal, I propose to create a new framework, not just replace something from past. And the creation of new framework, as I know, and we saw that it's a really hard and complicated process. It will take a lot of time, I can say. It cannot be happen in the short period. But as we saw from another international crimes, we did it previous times, like 1998, we had Roma Statute ratified by countries, states, and we established International Criminal Court. And by this way, actually, we gave a status as an international crime to genocide because even before this trend, because before this establishment of the International Criminal Court, even these crimes are not considered as international crimes. But we did initiative and we make that, and I think we can do it for ecocide, because the most important thing, to be honest, from my perspective, we don't have any urgent or other, I don't know, more important thing rather than our planet, and that's why we have to take action. And with establishment of the treaty and ratifying by states, we can make obliged to member states to criminalize ecocide in their own domestic jurisdictions, to add I don't know, criminal codes. And after that, we can say that ecocide to be considered as an international law, international crime, because before that we cannot say. Even approximately, I can say maximum 20 countries in our world just recognize ecocide as a real crime, but we have more than 200 states, and we should take action with this treaty. This is a new framework, I can say. Actually, it's my initial proposal, and I'm planning to proceed with this way, with establishment of a new instrument, because in our current world, in our, for example, Roma Statute is not fit and meet these requirements because of the no corporate liability. Also, making amendments to Roma Statute is also not a simple work. It's also complicated because we require 2/3 state parties have to vote it positively about the amendments. And after considering that, yes, okay, we amend the Roma Statute and simply mention that ecocide also is an international crime. But after that, after enforcement part, we will have the same situation and we'll have same difficulties about the implementation. And that's why I'm proposing it. And I hope I can just give some answer to your question. And I hope my colleague Vitor continue with the other part.
And just to add to your point, I just remember this, the cultural heritage for the online people. So, for example, the cultural heritage, if they are protected and if they are destroyed and destructed, then it could be considered that crime has been taken place because they have, for example, the cultural heritage generations. So something these seems to be tangible. They are destroyed and destroyed. Otherwise, we use considered that crime has been intragenerational because they have, for example, the culture rather than particularly focusing on crime itself. Thank you.
I'll try to ask to answer the two really good questions you asked me for, and I'll go to the third one. My first answer is who is accountable here? In the Brazilian legal framework, it would hold accountable the person who did that and the company as well. This is kind of unthinkable in the German legal framework, right? I don't know if you punish the company.
Not specifically in criminal law.
Yeah, and we do that. So
no, we don't. Like it's a fine, but it's an administrative one.
And then we would punish through criminal law the company as well. The higher sanction here would be closing the company, which is a death penalty in some way. Which is interesting because when we have this kind of decision, they I don't know if that's the right word for the right technical word, but they merge the company to another company, and it's like when the person dies, there is no more penalty, and then the company dies, and then there is no more penalty as well. Then there is a huge problem there. But we also held the person accountable. In the case of Mariana and Brumadinho disasters, they were all acquitted, also for procedural reasons, but they were all acquitted. They had charges on homicide as well. That was strange in some way. Well, but that is the answer of your question. We would, in Brazil at least, punish the person, the individual, and the company together. And then how can we discuss in a national level ecocide? We have two bills that try to create an ecocide crime in Brazil. They're not being discussed at all. People are not really interested in the Congress, in Brazilian Congress, on environmental topics. But the bills have many problems. They don't tell us, the citizens, what exactly is ecocide, what exactly is a serious environmental harm. So I think there are other questions here to be asked, but I think in a national level, as my friend was saying, the answer would be to join the democratic discussion in the legislative and see how it works out. This is our responsibility as well as scholars to go there, to talk to them, to see if the bills can work, if they are legitimate, the criminal provisions are legitimate. But and the third question, could you repeat that for me? I forgot to.
If you can elaborate on the point, as you mentioned about the personal companies, but if the states is doing, as you mentioned about that, the nuclear or some kind of disaster which has happened.
Yeah.
So the responsibility of the states as well. If the crime, if that, what kind of punishment you would like to suggest?
Yeah, we in our history in Brazil, we didn't have any kind of nuclear problem still. We had not a nuclear problem, but in the 80s, there was two guys that they found an X-ray machine, and they found a radioactive part of it, and they found it really shiny and funny, and they brought to their homes and called everyone, and everyone was putting in their skin, etc. And people died because of that. It was not a disaster, but it was also something that called our attention. But in this case, we have crimes related to nuclear energy in Brazil, and that would also hold the for people and company accountable. It wouldn't be a problem for us, although we never had a problem like that, and that we have two, I guess, nuclear facilities in Brazil. But I think that's it. Thank you.
Okay. I think we really have to like leave on time. Okay.
Yeah, I think, well, if there's one more question, we can do that, but else being on
Yeah,
time.
we do have one last question from the Zoom meeting chat. And to reach parity, it's for Rafael. And the question is, considering the jurisdictional limitations of criminal law in transnational digital contexts, what concrete mechanisms do you consider most effective to combat the illegal online trafficking of felines, especially when actors operate from countries with weak or absent legal frameworks?
Well, thank you for the questions. But the first step, I think, is uniformization the frameworks in our countries first. But second, I don't think everything have solutions with the rules, so with the laws, with the frameworks. We need effective officials, capacity with forensic preparations, and the relations of the countries and the system judicial that exist behind that. It's important because the crime now don't occur only in a country. For example, we recognized yesterday someone talked about the global south and the global north. And the global south, we provide all the products like this, felines, like cups, parts of lines, and the global north provide the technology and also the offering to the trade, to the legal trade. And we have to work together to make an alliance to combat the traffic feline. I think that it could be the way the controllers, obviously, the efficient way the traffic feline in this way. Thank you.
Okay, great. Thank you so much, all three of you. And we will now change our venues to Buceros Law School and continue at 7 p.m., right? Great. Thank you so much.
So for everyone, the Buceros Law School is right next to the hotel for speakers who are sleeping in over the conference. Otherwise, we're going as a group to the Buceros Law School. If you want to go with us, if you
who is accountable here? In the Brazilian.
Just be there at 7. We will have a great panel with very exciting speakers. I'm particularly excited for the judge from the Shark case. But the others are great as well. And afterwards, we have a reception with alcohol, snacks, so a nice Friday evening experience. Yes. So if you want to go with us, we will, I think, leave at around 10 minutes, just from the foyer below. Yeah. Perfect.
Get some real pictures, maybe.
Ja, die reibungslos. Okay, weil uns aus kann alles ja. Wie bei der Übergang zu wir müssen
Oh, I didn't realize my job in that is. Thank you.
I could have done this was great.
Genau.
We will run over to your text and we'll see you.
Kurz erzählen, warum wir lassen was trinken raus. Genau.